concern, which is about fair and balanced contracts, and that's come up several times during the course of the discussion. So I'm going to ask Nigel and then Barbara about this fair and balanced. But if you have in front of you a set of contract documents for architects which are fair and balanced, we know that, and you're presented by your client with something else, how do you know that that's going to be as fair and balanced as these? Because it isn't just fair for the client, it's also fair for the architect, and the point is balance is what we're looking for.
But I suppose the issue is that both parties perhaps have a slightly different view of what's fair and what's balanced.
Yes,
which is why we have lawyers, of course, because often there's disagreement over that. And I mean, one of the things that we have to do is, one of the things that the standard form has to do is to try and be as fair and balanced as possible, because if it's skewed too much to the architect, clients just won't use them. So they want to see that there is some degree of fairness, but at the same time, we don't want something which is too biased towards the client and puts all the risk and liability onto us. So it has to be genuinely fair and balanced. And so these have been put together over quite a period of time, these standard forms, and a lot of that has been thinking about what is the right duty of care? How are we going to express the duty of care, for example? How are we going to express the level of liability that the consultant will carry versus what the client might take? And it's complicated, and that's why it's better to leave some people who know what they're doing putting these things together, rather than us as individuals trying to work it out as practitioners. Because whilst we might have a pretty reasonable understanding of the law from an architectural practitioner's point of view, we don't have the sort of thorough legal understanding that the people who have written these contracts.
So I'm going to ask Barbara then if there's an issue. You mentioned that you, as a small practice, do public sector work, and they're giving you their own contracts. How do you ensure that those are fair and balanced? Or do you just sign them anyway?
No. We do not just sign them anyway. But it is really tricky. And we usually, to get a public sector contract, you go through a selection process. And you get selected for whatever a proposal you have made. So there is a certain buy-in from the client already, which gives us the confidence to actually go back to them and say, look, these contract clauses just really do not work. They are not fair. Our insurers, lawyers have flagged them up. They're flagged red. It's in no one's interest if we sign this, and please amend them. Because also, it is also not in the interest, because of course these bespoke contracts are biased against us and towards the clients. That's why they are bespoke contracts that sort of public sector, local authorities put forward. But it's not in the client's interest either if our insurance says, well, they will actually just not cover us.
Absolutely.
I think the point is that we have to negotiate. This is the thing. And I think sometimes architects have perhaps been guilty in the past of taking what they've been given, saying, well, I feel like I have to sign this. But actually, I think we'd encourage people always to look carefully at the terms and conditions. Ideally, get your insurers, as you say. Most insurers give some free advice, legal advisors if you can afford them, to have a look through and check it, and then go back and have a go at negotiating.
Well, based on the fact that we already have forms of appointment which are fair and balanced, we really have a good starting point for that discussion and negotiation, don't we?
We also have a responsibility under the code that says if we're not able to deliver something, we need to make sure the client's aware of that. And so I think with these bespoke forms of appointment where there is a lot of transfer of risk upon us, if we're not able to manage that risk, we have a responsibility to say to the client, we cannot do this. And I agree with you, Barbara, it's in their best interest. There's no point of signing up to something if we can't do it, because ultimately the client loses, particularly if there is a claim and we're not insured.
But what we've been talking about now is sometimes you're saying that architects feel under pressure to sign, and very often that pressure is because they're already part of the way into the project, and a client will say, well, sorry, look, unless you've signed up to this, I can't, my accounts department won't let me process your fee. So that actually is a very good practical reason and argument for having these appointments in place from the beginning. So
yes, certainly it is.
Aside from a legal, there's a practical benefit to architects in having that from day one.
And on Nigel's point of negotiation, I would say really negotiate everything, not just the fee, actually also negotiate the limit of your liability as hard. And it's sort of important to know from a small practice perspective, again, just talk to the insurers and get them to send you customized verification certificates for any limit you want, really. I mean, you might hold higher PI than you're offering, and really try and keep it low as is obviously fair and reasonable, but don't over-provide.
That's a good piece of advice.
The insurers like it.
What
keeps premium
What
low
about
as well.
the opportunity, which is now in the paperwork here, for the architect to do the principal designer role? Does that have any impact on this fair and balanced contract?
I think certainly we need to make sure where we're providing principal designer services, we definitely have the contract in place. There's a legal obligation under the CDM regulations to make sure that appointment's confirmed in writing. We also need to be aware of the duties under the CDM regs when we're talking about the duties to do what we can so far as reasonably practical. So again, we need to make sure that's reflected in the contract so we don't then end up raising the bar, particularly when we're talking about health and safety issues, where the repercussions can be so serious.
I think there are a number of reasons why it's important to have a separate appointment, and there is a separate appointment in these standard forms for principal designer. One of those is that the services might be of a different duration. So you might well be the architect from inception through to completion, but you might be the principal designer, perhaps only up until the point when the principal contractor comes on board. It's certainly something we look to do these days. We think the principal contractor is in a better position to perform the principal designer role in most cases. So that allows that differential between the two roles to be expressed. And the other thing, of course, is that, and I think this is probably true more for smaller projects, from my understanding, than for larger projects, that clients might expect the principal designer role to be just thrown in as an additional service.
Yes.
And so having a separate appointment does give you the means to explain that actually it is a separate role. It is a role that is fundamentally best performed by the architect as lead designer, but nonetheless it is a separate role, and it gives you the ability to have that conversation, explain what the role involves and why it's important, that the client has duties under the CDM regulations as well, but that we can negotiate a separate fee for it.